Okay, I'm reading the California Civil Procedure Handbook rules, selected statutes and cases, and comparative analyses. I'm in Chapter 4, the proper court, and I'm about to read about service of process. I'm on page 95, sadly. 1. Introductory note on manner of service. CCP 41310 provides, except as otherwise provided by statute, a summons shall be served on a person within the state as provided in this chapter, B, outside the state but within the United States as provided in this chapter, or as prescribed by the law in the place where the person is served, and C, outside the United States, provided in this chapter, or as directed by a court, and if the action is pending, or if the court before or after service finds the service is reasonably calculated to give actual notice, as prescribed by law of the place where the person is served, or as directed by a foreign authority in response to a letter rogatory. These rules are subject to the provisions of the Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matter, Hague Service Convention. Together with the proper personal and subject matter jurisdiction, proper service of the complaint and summons on the defendant is a prerequisite to a valid judgment. See Lane, Central Hanover Bank and Trust Co. of 1950, discussing constitutionally adequate notice. What about it? Is prerequisite to valid judgment. Insurance Corp of Ireland, first. Compagnie de Sydney of 1982. The validity of an order depends on the court having jurisdiction over both the subject matter and the parties. The Jurisdiction and Service of Process Act, enacted in 1969, governs service of process of the California Court, CCP Section 410.10, and sequential. Generally speaking, the proper manner of service and the person upon whom service must be made depends on the place of service, where service is to be served, for example, within California, in another state, or outside the United States, and the type of party to be served, for example, an individual defendant, a corporation, or association, or a public entity. Next page. Service within California. Personal service. Personal delivery of a copy of the complaint and the summons is the preferred manner of service upon defendants within California. CCP 415.10 individuals, CCP 416.10 through 1690, corporations, associations, and public entities, guardians. Substituted service on individuals, and the requirements for substituted service on a person are found in CCP 415.20b, which states, if a copy of the summons and the complaint cannot, with reasonable diligence, be personally delivered to the person to be served, as specified in section 416.6, 0.60, 0.70, 0.80, and 0.90, a summons may be served by leaving a copy of the summons and of the complaint at such person's dwelling house, usual place of abode, usual place of business, in the presence of a competent member of the household or a person apparently in charge of his or her office, place of business, at least 18 years of age, and who shall be informed of the contents thereof, and by thereafter mailing a copy of the summons and of the complaint by first-class mail, postage of the summons and of the postage prepaid to a person to be served at the place where a copy of the summons and of the complaint were left. Service of the summons in this manner is deemed complete on the 10th day after mailing. Substituted service. on an individual defendant pursuant to CCP section 415.20b is authorized only when process cannot, with reasonable diligence, be personally delivered. What constitutes reasonable diligence in this context? See Bain v. Brechtel, Jochum Group, Inc. of 1992. Ordinarily, 2 or 3 attempts at personal service at a proper place should fully satisfy the requirement of reasonable diligence and allow substituted service to be made. 2 or 3 attempts at personal service at a proper place. Compare Espinolda versus Nunes. All of this is really important for a specific person that I know. Okay. Now, talking about 3 to 4 unsuccessful attempts. Okay, a couple of things worth highlighting actually in this service section. Some keywords. I mean, first of all, 3 unsuccessful attempts within 4 days. Now, we filed before to post service by newspaper under those circumstances and have totally been denied. That's fine. This Mullane versus Central Hanover Bank is an important case. I think it's where comes the language reasonably calculated to give actual notice. So I'm just highlighting that. Letters rogatory are a real thing from the Hague Convention. But I'm not highlighting that. Anyway, let's keep going. After the three unsuccessful attempts in 4 days to personally serve at a constituted reasonable diligence, sufficient to uphold substituted service on defendant's wife at home, with Everett v. Superior Court of 1979, which held that 3 unsuccessful attempts within 2 days to personally serve a defendant at home while defendant is on short vacation is insufficient to uphold substituted service. On a defendant's house sitter where plaintiff made no attempt to personally serve defendant, a longtime resident, until 3 days before expiry of the 3-year period in which plaintiff must effect service. Oh, fantastic. This is really long. Substituted service on entities. When a defendant is a corporation, an unincorporated association, or a public entity attempted personal service on someone in charge of the office during usual office hours, that's not a sentence. But it comes from CCP 415.20a. Why is a reasonable attempt at personal service a prerequisite to substitute service with respect to individual defendants and not entity defendants? Anyway, federal rules compared. Rule 4E of the Federal Rules of Civil Procedure authorized substitute service on someone residing at an individual defendant's place of abode as an unqualified alternative to personal service. Likewise, the vast majority of states recognize substituted abode service as a primary method of service. Only California and a few other states relegate it to a secondary method of service. Oh, okay. Substitute service of process on individuals, Code of Civil Procedure, Section 415.20b. Hastings in 1970, arguing that the requirement of reasonable diligence in CCP 415.20b unnecessarily restricts use of substitute service without significantly improving the likelihood that the defendant will actually receive notice. What policy considerations support California's view of substituted abode service, and what ones support the federal or majority rule? Well, I'm all for the federal and majority rule. But California is questioned. Construct service by publication. This is what I was talking about, motioning for. CCP 415.50 permits constructive service by publication only where the court is satisfied that the party to be served cannot, with reasonable diligence, be served personally or by substituted service. Those are the magic words. The reasonable diligence necessary to uphold an order for service by publication under 41550 requires more exhaustive attempts on to locate the defendant than is sufficient to uphold substituted service on the individual defendant pursuant to 41520.b. See Olvera versus Olvera of 1991. In that case, the standard of diligence required includes recent inquiries of relatives, friends, and other persons likely to know defendant's whereabouts, such as city directories, telephone directories, tax rolls, and registered voters, and inquiries of occupants of all real estate involved in the litigation. The plaintiff must not only exercise due diligence as a prerequisite for an order of publication, but must show due diligence in the application to the court. Yeah, it's an application. It's not a motion. It's an application. Anyway, service by mail within California. Code of Civil Procedure 41530 authorizes a very limited form of service by mail within California. The plaintiff must mail copies of the complaint and summons, along with 2 copies of the notice of acknowledgement and a prepaid self-addressed return envelope to the defendant. CCP section 41530B requires the required form and contents of this notice and acknowledgement. See also form POS-015 Judicial Council form. Service is not deemed complete unless the defendant executes and returns acknowledgement of 415.30C. Consequently, if the defendant fails to execute or return the acknowledgement form, the plaintiff must serve the defendant in some other proper method. The defendant may, however, be liable for reasonable expenses incurred by plaintiff in serving the defendant by another method. Rule 4D of the Federal Rules of Civil Procedure as amended in 1983 authorizes a similar method of service by mail within the U.S. referred to as request for waiver of service. In what category of cases is this type of service likely to be effective? So it's apparently never used according to a partner at my last firm. Next section, 3. Service on defendant located in another state. Service options. The plaintiff has many options when required to serve a defendant located in another state. CCP 41540 authorizes service of process on a defendant in another state in any manner provided by the Jurisdiction and Service of Process Act for in-state service plus service by mail. Additionally, CCP section 41310B authorizes service in another state in accordance with the law of the state where the defendant is to be served. Service by mail, return receipt required. Yeah, that was my next question. CCP 415.40 and 417.20B authorize service by first-class mail requiring a return receipt on the person in another state where actual delivery is established by the signed return receipt or by other evidence. What are some examples of sufficient other evidence? In Remarriage of Tusinger from 1985 explains. A letter written by the defendant's attorney in Arkansas acknowledging the defendant's receipt of the complaint and summons constitutes sufficient other evidence. Taylor Rush v. Multitech Corp. Of 1990, while a return receipt signed by someone authorized by a non-resident defendant to sign for his mail is sufficient, the plaintiff must provide separate evidence establishing the authority of the person who signed the return receipt on defendant's behalf. Substitute service on agent within California. In a wide variety of situations, California statutes authorize substitute service on the designated agent of the defendant within California. For example, corporations, partnerships, and other entities doing business in California must designate an agent for the service of process within the state. See, for example, Corporations Code 1502 through 1505, 2105, 2107, 1701, -2, 2110 through 2111, 0210, and 8210-12 various domestic and foreign corporations. Right, so these probably all are relevant to just general corporate law organization. And section of the Corporate Code 15627 for partnerships, Insurance Code 1600 to 1605 of insurance companies, and now we go back to CCP 416-41610 through 40. If no such agent for service or process is designated by the entity, substitute service may be made upon a California Secretary of State or other appropriate governmental agent. Interesting. See Corporate Code 1702 and 2111, and lastly 15627C. Vehicle Code 17451 provides that ownership or operation of a motor vehicle within California by a non-resident is the equivalent to an appointment of the Director of Department of Motor Vehicles as agent for service of process in any action arising from the accident resulting from operation of the motor vehicle in California. If the plaintiff serves process on the director pursuant to this section, the plaintiff must also mail a copy to the defendant. Substitute service on a designated or implied agent is alternative to, not exclusive of, the other statutorily authorized methods of service on a defendant. M. Lowenstein and Sons, Inc. v. Superior Court from 1978 shows plaintiff serving non-resident corporation may serve designated agent pursuant to CCP section 41610, or alternatively may serve by mail pursuant to CCP section 415.40 and Anderson v. Sherman of 1981 involving an injured California resident may serve as a non-resident motorist pursuant to Vehicle Code section 17,454 through 455, or this section 415.40 of the California Code of Civil Procedures. We're in part 4, still within service. Let's continue. It's about 3 more pages. The Hague Service Convention. Oh, this is service outside the U.S., by the way. The Hague Service Convention. The United States has ratified 2 multilateral international agreements which govern service of process among signatory countries. One is the Hague Service Convention, ratified by the United States in 1969, which now includes other signatories as Canada, Japan, the People's Republic of China, the United Kingdom, Germany, and most other European countries. And there's a crazy citation here, which is totally different than any other one I've seen in any of my case books. 20 U.S.T.361 to 73, T.I.A.A.S. Number 6638, 658 U.M.T.S. 163. So that's an international convention citation. For a complete list of all parties to this convention, I'm about to put that in Google and see what happens. For a complete list of all parties to this convention, see the United States Code annotated sections following Rule 4 of the Federal Rules of Civil Procedure. Yeah. J, specifically, because I've gone over this and over this and over this. I don't even know where I'm reading it right now. J, to be specific, Rule 4, J. Articles 2 through 9 and 19 of the Hague Service Convention authorized uniform procedures for extraterritorial service of judicial documents through a central authority designated by each country through diplomatic channels or by any method permitted by the internal law of that country where the service is made. Article 10 authorizes additional extraterritorial service methods, including direct service by mail, but only if the receiving country has ratified and not objected to these alternative methods. Consequently, a determination of the availability of these alternative methods requires an examination of the receiving country's accession to the convention as set forth in each country's declarations concerning the Hague Service Convention. These declarations are reprinted in the United States Code annotated sections following Rule 4 of the Federal Rules of Civil Procedure. The declarations must also be consulted to determine each signatory country's requirements with respect to the translation of documents to be served. The United States Supreme Court in Volkswagen Work AG versus Schlunk of 1988 indicated in dicta that by virtue of the Supremacy Clause, the Hague Service Convention preempts inconsistent methods of service prescribed by state law in all cases to which the convention applies. CCP Section 413.10c requires the same deference to the convention in the California courts as does Rule 4F of the Federal Rules of Civil Procedure in the federal courts. For commentary and analysis of the Hague Service Convention, there's all types of other things you can read. Inter-American Convention. The U.S. ratified the Inter-American Convention on Letters Rogatory in 1986. This convention, which includes Argentina, Guatemala, Mexico, Paraguay, Peru, and the United States and Uruguay among its signatories, authorizes international service of process by methods very similar to those in the Hague Service Convention. This convention is reprinted in 14 INT '(L) leg. Mat. 339 of 1975. So it took them 6 years to publish it, with additional protocol reprinted in another place in 1979. For commentary on the Inter-American Convention, see Lucina A. Lowe and Richard D. Kearney, because they've written texts on it. Section 5. Procedures for asserting lack of proper service includes a motion to quash. A challenge to the validity of service of process must be made by filing a motion to quash on or before the last day to plead in response to the complaint, CCP Section 418.10a and b, pursuant to the 2003 amendment to 418.10. The defendant need not raise the objection by a special appearance, but may simultaneously answer demur or move to strike so long as the objection is raised in defendant's first appearance. CCP Section 418.10e, effective January 1, 2003. If the defendant makes a general appearance as defined in CCP 1014 before filing a motion to quash, objecting to the lack of proper service, the defendant waives his right to contest the validity of service. Next paragraph. When a defendant properly moves to quash service of process, the burden is on the plaintiff to prove the facts establishing valid service. Dill v. Bergquist Construction Co. 1994. Taylor-Rush v. Multitech Corp. 1990. However, the return of process server, I'm just going to write this down. It's emotional to write that down. However, the return of a process server registered pursuant to section 22,350 and sequential of the Business and Professions Code establishes a presumption affecting the burden of producing evidence of the truth of the facts stated in the return. Evidence Code Section 647. This presumption arises only if the proof of service complies with the statutory requirements requiring such proofs. See Dill v. Bergquist again. Supra. That proof of service which showed that the complaint was mailed to the wrong corporate officer raised no presumption of proper service. Really? Anyhow, if a motion to quash is granted, the service is quashed, but the action is not dismissed. The plaintiff may attempt to perfect the court's jurisdiction by obtaining valid service, subject to applicable time limits for service such as those in CCP Section 583.210 through 583.250, Roberts v. Home Insurance Indemnity Co. If a motion to quash is denied, the defendant may obtain immediate appellate review by a writ of mandate. Part 6. Time limits on service of process. Mandatory dismissal. A complainant summons must be served upon the defendant within 3 years after the action is commenced against the defendant. Section of CCP 583.210A and 583.110. Return of service or other proof of service must be made within 60 days after the time the summons and complaint must be served upon the defendant. 583.210B. These time for service requirements do not apply if the defendant enters into a written stipulation or does another act which constitutes a general appearance. Section 583.210. Other exceptions to time exclusions are set forth in that section, that very same section, and 583.240. Failure to serve within the prescribed time will result in mandatory dismissal of the action according to 483.250. Discretionary dismissal. Service not made within 2 years after the action is commenced against the defendant may result in discretionary dismissal for delay of prosecution pursuant to section 583.410 and 583.420A1 and rules 3.1340 and 3.1342 of the California Rules of Court. Court rules. Rules of Court, that is. Rule 3.110 requires service of the complaint on all named defendants and proofs of service filed within 60 days after the filing of the complaint unless the court orders an extension of time. Rule 3.110B and E. California Rules of Court. Likewise, many local fast-track rules of service of the complaint within 60 days of its filing. For example, Orange County Superior Court Rule 483 and San Diego Superior Court Rule 2.5 don't give me anything relevant to San Francisco, Sacramento, or anywhere in the world in Northern California. Part 7. Process servers. A summons and complaint may be served by any person who is at least 18 years of age and not a party to the action. See section 14.10. Consequently, although state laws also authorize a sheriff from Government Code 26608, marshal server from the Business Code 22,350 through 58 to serve the complaint and summons, the plaintiff has the option to select any adult individual to serve these documents. That's right, but that section of the Business Professions Code says they can't do it more than 4 times. Now, section 8, proof of service. After a summons has been served, the summons must be returned together with proof of service as defined in CCP section 417.10 and 417.20, CCP 417.30A. See Judicial Council Forms POS-010. Actual service of process vests the court with jurisdiction to act in a matter rather than proof of service. Oates v. Oates of 1983, Willen v. Boggs of 1971. Proof of and return of service, however, must be made within the required time limits of we just discussed of 583 to 10 of CCP to avoid mandatory dismissal. See Johnson v. Johnson v. Superior Court of 1985. The last section of this chapter will be forum non-convenes. It will be a short read.